actually, can I raise something first, just with you, Tom?
Yep.
And that's the question of what happens if an insolvency arrangement breaks down, if somebody doesn't keep it up?
Well, I suppose the key thing is that obviously, I think, people enter into these with good faith, okay? And it may be a situation that an individual enters into one, there's a reason in the family, there's additional cost, and maybe somebody loses their job for a month or two. But after 6 months, in arrears, for example, in the PI, it automatically fails. So there is a little bit of a buffer that we're not in a position to deal with the issues, but it will fail after 6 months.
Yeah, it will fail, but what happens to debt then? Comes back in.
All the debt comes back in, and you're fully liable, less what you've discharged during the procedure.
Right.
So you're fully liable for everything again.
So the penalty is absolutely huge.
And actually, there's can I just make one point? And I'm sorry, there's something I didn't. I was rushing in there that I meant to say in the notes is that one thing why people may consider bankruptcy. Another thing is that if you look at it, and one of the key things is you go into a PIA in Section 103, Paul. You go into a PIA and you enter into a thing to write down a scheme to write down secured debt. But there is a potential clawback that if you sell that you come out of the arrangement, that there may be a clawback if you sell it at a profit, for want of a better way of putting it. So you think you're out the gap, but if you don't read the clauses very tightly and very carefully in the arrangement that you enter into, that it may be a situation that actually, you know what, you think you've discharged your obligations, but in effect, any profit in the property that you think you're out the gap with is gone.
First of all, it's a great presentation, fascinating watching over the day how this is evolved. So first of all, thank you. Secondly, I have two very brief questions. Firstly, as a lawyer, first question I want to know is, do you kindly know what the PIP could have from charge, what are the estimates on that figure?
Well,
very good. Now, hold on a second. Let's just take the two.
Second question relates to the MABS procedure. I understand the banks are issuing standard financial statements. Now, in practice, I've seen a couple of them where the banks would add a couple of terms conditions which the bottom about the borrower having to provide consent for medical records, for family and friends, for work, employees, all that type of stuff, which quite frankly is a bit following. Is there a standard set in that?
Mine is a question for Tom. I was just wondering, is it possible to get opinions in relation to the PIPs and how they would advise somebody thinking about going into one of these sort of arrangements, or do you always have to go through the approved intermediary? Do you have to be with MABS before you can
Okay. Thank you very much.
That's a good question. Okay, I suppose just to deal with the first thing about the fees, and then that lady's question there in relation to the process. I suppose in relation to fees, quite simply, the market will decide what the level of fees would be. Nobody really knows at this stage what they'll be, and I suppose but I do know what it can't be at the level that practitioners, given the level of regulation, given the level of cost of actually every PIP. For example, in my practice, there'll be perhaps 4 or 5 people who are going to act as PIPs. For each PIP, there's a registration fee of €1,500. For that has to be on an annual basis, then has to be renewed at €1,000. We then have insurance issues. We then have all those other costs. So it's very hard. There will be a fee involved. I think initial consultations would be like an hourly consultation would be €250 or €300 perhaps. And again, I don't know. But I think if you look at the way the fees will be structured, I think there will be an initial consultation fee. I think then there will be a fee for perhaps negotiating. If you then appoint somebody, a fee up to negotiation stage, which will have to be funded by the individual. And then after that, the level of fees will be approved by the creditors and set by the creditors. Okay, but I think if somebody says they're going to look at it for nothing, that says to me they're in a volume game. The reality is professional advice, and good professional advice has a price. And I think, unfortunately, in the insolvency profession, has sometimes ignored that. Certainly on the corporate side. But I think an initial consultation for people in difficulty, because we're all here today and we're all intimately involved in the issues that people are facing, and we don't know the answer, and you have a room full of experts here. Okay, so the reality is good professional price has a price. The lady's question as in relation to whether you have to go to an approved intermediary before you go to a PIP. Well, I suppose the approved intermediary just deal with the DRN. And the PIP, I suppose, is more or less is dealing with the DSA or the PIA. So if an individual, unless they have less than 20,000, someone who has less than 20,000 euros is not going to come in to see a PIP. They're going to go straight to the MABS or who are an approved intermediary, or if anyone else has made that. So the AI, the approved intermediary, and the PIP are two concurrent processes, but you choose one or the other depending on your profile. When you come into the PIP, then they will then look at your circumstances. They'll do their own due diligence perhaps on you, and then they decide what They'll gather information from you, they'll do their due diligence and advise you on what is your option. PIA, DSA, perhaps a DRN, maybe you've jumped the gun and come to the wrong stream, for want of a way of putting it, or indeed bankruptcy. Okay? Does that?
And can I check that with Colette as well, whether you just look when somebody comes in for the approved intermediary, do you look at other options for them as well?
Yes, as part of the process for an approved intermediary, they will have to look at the other options available. So it may be the case that given the level of excludable debt that a debtor may want to be permitted, they'd be better off going for DSA if they have sufficient net disposable income to make such an arrangement. Similarly, voluntary arrangements, it'll be unlikely that somebody coming for a DRN would go for PIA given the secured asset piece. But yes, I mean, we'll have to go through all options available.
And then there's the question of the standard financial statement and this consent for, additional information and the rest of it. Do you want to talk a little bit about that? Or?
Well, I mean, there's no requirement in the revised code or the existing code for a borrower in arrears to hand over or provide any medical records. There's no specific requirement to that effect. The ASU most places assessment on the borrower's full circumstances, personal circumstances, overall indebtedness, the standard financial statement, repayment capacity, and the borrower's history. There's nothing specific about medical records of any kind. Now, whether a lender would try to get that in under the personal circumstances of the borrower is open to question. The problem that you have here is that this is still a creditor-dominated process where ultimately the lender makes the decision. But certainly I think if a lender was imposing onerous requirements in terms of information that is not set out in the CCMA itself, I think that's grounds for appeal. Whether you'd want to appeal because the appeal is internal, but then is also to the FSO, because looking for that kind of detail goes to the borrower's treatment under the code. Can I just very briefly say, just on the question of fees, because I think it is something that we have raised. The problem that we would certainly see is upfront fees being charged. Now Tom has specifically said, fair enough, that there will be a consultation fee. It's very clear from looking at the legislation that there's a huge amount of work to be done to take the borrower from an initial consultation all the way to the creditors' meeting, through the protective certificate, the circuit court, and so on. Where no outright ban on upfront fees been charged, even if there was, that would lead to a lot of insolvent debtors not getting to talk to a PIP. Given the fact that there isn't, there are going to be upfront costs, and FLAC has consistently called for some kind of equivalent to legal aid, some kind of public insolvency element to this legislation that will enable people who can't produce an upfront fee to still apply for arrangements under the legislation.
Okay, thank you. Colette, do you want to?
Just sorry, to add in relation to the standard financial statement, it's actually defined within the code as being something that's issued to lenders by the central bank. So everybody, I'm sure, has seen the 12-page document with the declaration at the back and the consent piece around ICBs. There is no further consent in the back of that. So if there is a lender imposing it, they aren't actually complying with the CCMA.
Right, that's very useful information. Thank you. Now,
Tom, you've researched this quite a bit. I mean, in terms of taking a case from start to finish, could you put a ballpark on a fee level that you would think would apply? And the second question is to the panel in general. If people have insufficient disposable income to pay the fees that are being charged, where do they go?
Okay, I suppose...
That was the same question earlier on, you forgot to answer.
You didn't ask it. No, we'll ask it now. We'll answer it now. I suppose the issue is... and I'm going to look like I'm not going to answer it, and then I will try and answer it for you. Okay, I suppose everybody in this room are an individual, and each of our circumstances are different. So it's very hard to say with any certainty that the average cost of the PIA is going to be 10,000, etc. But I'd imagine that initial consultation will be somewhere, depending on the firm you go to and the experience that they have, somewhere between 250 to 500 euros for the initial consultation. I'd say, well, it's not the average, 300 will be the average that will be charged. I think in relation to then negotiating for a deal, to bring it up to the creditors' meetings, etc. And as Paul pointed out, I think it was Paul, that there was substantial work in that. I think it would be somewhere between 1,000 depending on the practitioner, up to 3,000, 4,000. And again, depending on, it could be 10,000 depending on the size and scale if we're dealing with a significant entrepreneur with significant debts. But I would have thought the average, the mean, and that will be somewhere around 1,500 to 2,000 mark. When you then go on to the scheme itself, it could be anywhere from 5 to 750 euros per annum, anywhere up. Okay? But that comes out of the asset realisations and effectively is funded by the creditors because it comes out of their realisation pot. Sorry?
So that would probably end up being a debt that would be included in...
Well, it'll be written off
Yeah.
as part of the thing. It will be funded by, will be part of, you're right, it'll be part of the scheme of
They
arrangement.
probably have to borrow it?
No, it comes out of the asset. No, to explain, it comes out of the asset realisation. So if you're selling a property, it comes out of the fund that comes up to fund the PA on a monthly basis. It is a cost of the PA, but it's ultimately comes out to the creditors, what's available for the creditors.
Thank you very much, Tom. Paul?
Well, just on the second part of Michael's question, which is if you can't produce the income, where do you go? Now, this arose in the first session. Do you have to apply for a DSA or PIA before you can file for bankruptcy? And my reading of the relevant section is that you don't necessarily have to. What the section says is that you must make reasonable efforts to reach an appropriate arrangement with your creditors related to your debts by making a proposal, etc., etc. But then it says, to the extent that the circumstances of the debtor would permit him to enter into such an arrangement. Now, that seems to me to leave it open for a debtor, for example, to see a PIP and for the PIP to say, I do not think you have the resources even to enter into a debt settlement or personal insolvency arrangement with your creditors. You simply can't produce a dividend. The question will be for Chris in that situation, will it be enough, for example, for Tom to write on headed notepaper, I saw Michael Doherty, looked at his circumstances, and I deem he doesn't have the income to make a proposal. Will that be enough to allow you to proceed to bankruptcy? That's a very interesting question, I think.
Thank you. Chris?
Okay, well, I mean,
Can you pull in a little bit to the mic?
I'll answer. It's in the pack, guys.
it is in the pack. The procedure for actually bringing this to the court is that your petition is accompanied by an affidavit. And in your affidavit, you swear that you have made reasonable efforts and you have, that makes it a lot easier, and you've not been able to succeed. Is this on?
Should be on.
It is, yes?
No, it's off.
It's off. It's off, is it? Sorry about that. Have you switched on? Expert.
The sound of it.
There you go.
Right, yeah, it's the red thing there. That makes all the difference. Okay, you hear me now. So you swear an affidavit, and in the affidavit, in my opinion, what you do, you would exhibit a lot of letters, and obviously, to the extent that you can get and pay maybe one consultation with a PIP simply to independently verify what you're going to do. But it will be the proofs, it'll be the letters, and it'll be the period of effort. And it's not Chris Lahan that makes the decision, it's actually a matter before the judge. So the judge cannot adjudicate until she is satisfied that reasonable efforts have been made.
So
and in my view, that would be sufficient.
Yeah. Can I just check then, say, somebody then going into bankruptcy can in fact go in really with less, you could conceivably be doing bankruptcies or administering bankruptcies with almost no income and assets in them, just debts over 20,000, because you no longer have a minimum income even to file in court.
Well, this is the reality. Most of the bankruptcies that I get most is property related, all negative equity, all owned by the banks, any cash gone, possibility of a pension, person not going to have an entitlement until they're 65, 60, and you're scraping around looking for money and there is no money. So, I mean, one of the difficulties, the insolvency service in England is insolvent. And the court service has been absolutely funding my office because I haven't made a bean. The amount of realisations, real realisations, where you have a house that has no mortgage, has been very, very rare. So, you're talking about, God, 650. The taxpayer is absolutely subsidising me with 9 staff. And when we move up to the insolvency service, I'll have 32. And we are actually looking at ways, because the English have had to say, look, we need to come up with a basis upon which we can charge fees. So we are actually looking at very unpopularly said in here, looking at a more commercial basis of trying to charge fees. And in England what they do is they cross-subsidise, they hit an administration fee, some states can pay and others don't, and they effectively cross-subsidise. But the whole basis is that creditors should effectively subsidise the process and not the state.
Yeah.
And the same way that if settlements are not done, it's social welfare and it's also the taxpayers that's paying. So there is a need to try and get a commercial basis for funding the official assignee's office, which is totally uncommercial. I'd be insolvent if I was out there as a private. And the other side of it is that this is exactly what's happening in England. The English do not want the Irish bankruptcies, these huge properties and no free assets. And they are tightening the procedures and making it harder for people than has been the position in the past. And I can tell you that because I was talking with them only last week with Lorcan. And equally in Northern Ireland, an awful lot of the bankruptcies are effectively assetless. And in England, the procedure is that the official receiver is the trustee of first resort. He looks to see if there is sufficient funds to call a creditors' meeting. And if he informs of you there isn't, he is the trustee of last resort. And effectively, it's the English taxpayers that are funding a lot of the ones that go about if there isn't free assets back in Ireland.
Okay, thank you very much. That's a useful insight. John, you were trying to...
Yeah, it's okay.
No, can you take the mic though, just for, I think it's
sure.
for the video.
Okay. I hadn't understood that there was a possibility of an upfront fee on the part of the debtor for the PIP process. My previous understanding had been that essentially either directly or because the PIP would be paid out of assets, that effectively the creditors would end up bearing the cost of the PIP process. On that basis, and you mentioned it, Tom, in your slide, isn't that yet a further encouragement to the bank to arrange voluntary settlements with debtors rather than pay these costs? And in another venue of legal practitioners, the view was expressed that all of this is an entirely elaborate arrangement to force the banks, either slowly or in one way or another, to come to voluntary arrangements with the debtors. The second point in this other venue, and this obviously wouldn't arise in a FLAC context, Noeline, because I hope nobody in a FLAC clinic is going to be advising people to go into bankruptcy or anything like that. But from the point of view of legal practitioners, there's a judgment awaited in a case where the legal advisors to a person is suing their solicitor and barrister for advising them to go into bankruptcy. And practitioners have been warned to approach this with extreme caution with their panel economic.
Yeah, thank you very much.
Okay, if I can, on a couple of things. I suppose the first thing in the first point you're making about the fact you weren't aware of the upfront fee, and I can appreciate that completely. But the reality is a lot of these schemes may get to the stage where they're not approved, and a substantial amount of the work is going to be done up to the creditors' meeting, and effectively practitioners are going to be working on. And why I would argue strongly why a fee should be prepared is so that PIP remains independent and focuses on a commercially survivable, a scheme that will survive commercially rather than have an incentive to get a fee. So I think I would actually argue that there should be a fee charged up to that to ensure, and I'm not saying that there's any cowboy PIPs, there won't, because it's going to be heavily regulated, but to ensure the clarity of the process. But unfortunately it is an additional cost. In relation to the fact of, is it an additional, the second comment that was made in the second part of that first element of your question, is it an incentive to banks to do a deal? I do believe initially with this process, banks will look, certainly in the single bank scenario, to do a deal directly, to save them practitioners' fees. To perhaps you take a 40-year-old who has a commercial life or a working life of 25 years left, why do a deal over 7 years if you can do it over 15 years? So I do think, I don't disagree with you, okay? The second part of your question was?
About be afraid, really, as I understood it, that as you're approaching this kind of work.
Oh, as opposed to, well, again, absolutely, and one of the key issues that I mentioned in my slides is the whole issue of negligence. And this will be a far more litigious area for insolvency practitioners on the corporate side of it. And this is where I do believe there'll be a significant number of individuals taking up the role, and I expect that to dramatically decrease over a period of 18 months to 2 years.
Okay, thank you very much.
I think implicit in what you said, in fact explicit in what you said, was why should anybody in this room recommend people to go to bankruptcy? Would that be overstating what you said?
It's simply because the judgment is awaited in a family matter, where the legal advisors to a party who was advised to go into bankruptcy is suing their solicitor and counsel for that. In fact, so it's a particular issue that has arisen and caution to you. But in general, in that venue, the view was to advise clients was to wait and see.
Okay. No, I mean, I suppose the only comment I'd make on what seemed to be your point is that bankruptcy is and should be a legitimate option for people who simply cannot pay their debts. You know, it should be the nuclear option, but if you're in a situation where you simply have no repayment capacity, and some people have got ludicrous situations. I have one bankrupt, went up the north and he got into, guess how many properties he bought? Now, he went to Northern Ireland to bankrupt himself, a mechanic from Galway.
12,
Guess.
12, 16.
178. So, you know, bankruptcy, how will you ever get the capacity to be able to get back on that ladder again? And then, like, I think what you're looking at is a range of options. And if I consider what the central bank are trying to do, it is precisely what you've said. It is trying to get banks to engage. It's what everyone has always been campaigning that they should do. Engage and go and deal. If it needs a little bit of debt forgiveness. And that's why, as PIPs considering getting out there, the latest protocol issued by the bank gives the layers of options that the banks will consider right through, I thought there was a bottle going to fall, right through to bankruptcy. So you'll see the tiered approach, interest only, and then it tiers up. And bankruptcy is, in their view, will be possibly 10%. So they themselves are looking at people where they clearly think there is nothing we can do for these people. You know, you can give distress windows where you give them options to get back on their feet, but there is some so ludicrous property and tax-driven, some of the worst cases I see, hotels, golf clubs around, multi-million things where people have gone way beyond, and now it's agricultural land. They will never have the capacity to pay, and bankruptcy will be the perfect option.
Yeah.
Okay, thank you. Paul, did you want to come in?
Yeah, I mean, just to say that, I mean, insolvent debtors will vary hugely under this legislation. The variety is infinite, and one of the reasons there will be upfront fees is the prospect of creditor rejection of the proposal, and that's inherent in the creditor veto. Our particular constituency would be the consumer debtor, perhaps with the mortgage in arrears, a number of unsecured debts in fundamental trouble, but who will have very little to produce but some form of income towards the proposal. Now, voluntary arrangements are fine, but one of the problems that's got us here is the failure to have a system that deals with all debts in a legally binding manner. And I would be very wary of deals being done outside the terms of the legislation for precisely that reason. Any money advisor in this room will tell you how difficult it is to get all creditors to agree to a proposal. And I think that the central bank's timing of the announcement of its pilot is quite disastrous, to be quite honest with you. They should have been announcing this pilot some years back, before the Code of Conduct was revised and the Personal Insolvency Act was put in place. If you saw the comments of the Irish League of Credit Unions, they're incandescent with rage that in fact they're been deprioritised under the proposed pilot and that mortgage lenders are being given priority. And I don't think the pilot as announced is going to fly very far because it doesn't take unsecured creditors into account. It's not just banks we're dealing with here, it's credit unions, utilities, money lenders, credit card companies and so on. You want to get an arrangement, it's got to be across the board. That's what the debtor needs, not partial agreements here and there.
But I don't think the central bank itself can, it is attempting to deal with the major people. But it is a huge flaw in it that it is not. It is attempting to be in a collective process pre the arrangement. But you're dead right the big problem with any arrangement, if you can't get everyone on board and one goes to the court and starts grabbing a judgment mortgage and grabbing security, it all falls. But it is a genuine attempt. I do believe it is a genuine attempt, and I do believe that it's got the stick of that if 50% proposals are not submitted and then they haven't announced the next percentage, and that may have a lot to do with that. You know, there's Moody's and others out there. If the central bank starts waving a stick and hitting the banks, and suddenly Moody's and the rest of them see the banks are actually going to force into huge debt, that will have huge implications for all of us as taxpayers. So it is the central bank moving the banks along, but ultimately they all go back to their board. So the central bank itself can put guidelines, and they're all separate. And then the credit unions have come out with their own views as well, so I won't comment on those.
Okay, thank you very much indeed.
Tom, a question there, and that is, I note in the presentation you mentioned that you will have pre-appointment staff. I wonder, could you just talk me through what you envisage to be the initial appointment?
Okay, thank you very much for that. Emma, can I bring you down here, please? Sorry, the third hand is back up there.
I just wanted to ask Mr. Joyce about write-downs. He said he'd get back to it.
Okay, thank you very much for that. And so would you deal with those two queries, and then I'd ask Emma to go right up to the back. So, Tom, can I ask you to be brief on the question, the pre-appointment?
Well, effectively, that slide dealt with, you know, where you're dealing with a significant number of volume of people coming in, but effectively it's a filtering process to ascertain and get initial gathering of information to see whether people are suitable for a DSA or a PA, or whether indeed they will be a DRN who would be more properly advised to join or to go off to MAP. So the pre-appointment staff would effectively be the first gathering of information, but not everybody in my firm or the large firms will be PIPs. There'll only be a certain number of actual PIPs. So they'll be like juniors, not junior, but initial staff to gather the information and do a lot of the collation of the information before we formulate the scheme.
Your initial appointment?
Did,
would that involve?
And so at the initial appointment then they'll be...
Well, at the initial appointment they'll come in, we'll go through, we'll have our own internal questionnaires, checklists, and we'll gather the information to get a feeling for the size, the scale and the nature of the problems that they're facing, so that we can then give an initial opinion as to whether they are suitable for a DSA or a PA or what, to get a flavour of what the issues and problems and the scale of the problems they're facing.
Okay, thank you very much. Now, Cole, can I ask you to address then the debt write-down?
Yeah, is this debt write-down on a mortgage? Yeah. I mean, one of the innovative features of the PIA and one of the litmus tests of the legislation will be there's a provision in the PIA sections that allows a personal insolvency practitioner, at least in principle, to propose a write-down of the amount owed on the mortgage to something approaching the current market value of the property from the existing capital amount. So say, for example, you owe the mortgage lender €300,000, but your property is now worth €200,000. The PIP can propose that the 300,000 be written down to something approaching the market value of the property, with, as Tom said earlier, a clawback if the property is sold down the line for a greater amount. Okay. The big question is, will those proposals be vetoed by the mortgage lender, or will the mortgage lender see the sense in allowing a write-down? Unsecured creditors are dealt with over the lifetime of the repayment arrangement, and then the person goes back to paying the mortgage in full. Or will properties be repossessed with the lender crystallising a huge shortfall? To me, the former makes a lot more sense. You write down the mortgage and capital and interest is paid on it, or you come to a rescheduling arrangement over a few years and then go back to paying the full amount. But again, this is still subject to the creditor veto. Ultimately, the creditor will decide. If you've only one secured debt, then effectively the mortgage lender has a veto on that proposal. But I believe that there are thousands of mortgages out there for which only a debt write-down of some form will be a solution. And the Minister himself has said that he expects to see write-downs in certain instances. And he has also said that if lenders are not playing ball, under the legislation with proposals that the legislation will have to be revisited.
I think what he has said, because we've been watching this a little bit, but he said he will consider new legislation. Yeah. Okay, very final question up here.
Hi, sorry, I have no background in this. I'm a debtor, I'm afraid, so my view is quite singular, but...
You're the real expert.
Well, my lender is Bank of Scotland, and they're not interested in engaging sensibly at all, and they're not one of the big six that are there, so I suppose, Paul and Colette, really, it's for you. Thanks very much for the great presentation. First of all, they're more interested in compliance than they are in sensible resolution. And if the Ombudsman is only interested in process rather than the content of the exchange, what's changed? I'm one of these guys that's probably in the middle of it, multi-lenders, unsecured debt, and the mortgage. If I didn't have the unsecured debt, I'd probably be okay. But Bank of Scotland aren't interested in trying to assist everybody or come to a sensible arrangement. They just want it all. And the credit union, who got me out of the hole with a credit card, I'm not going to leave them high and dry. So what's changed pre-PIP? I feel as though I'm being forced down the PIP line, whereas I really shouldn't be. And then I'm concerned then with the PIP side of it, in that we're going to have a vast number of PIPs who are entirely unrelated. So I'm concerned about the consistency of advice and the consistency of deals when the banks have been so belligerent in their approach. Okay, so 18 months' time, the Tom says that it'll reduce to a number of firms, but 18 months out of a 5-year life cycle is almost 30%. So,
Okay, and I tell you what, I'm just going to ask you to be very succinct.
Oh, it'll be
it's
succinct.
a great final question, I
Okay.
think, because it'll sum up
Okay,
a lot of the issues.
well, the first thing I'd say is in relation to the consistent advice, I'm not one for regulation, but this is one area where I do believe in regulation. And it's one area where I will compliment the ISI. They have put in place a regulation, and as a supervisory authority, PIPs will be regulated. The reason people will leave the profession is because of the level of regulation. So I would layer fear, or try as much as I can before it's in effect, layer fears the quality of the PIPs. ISI, that's one thing we can certainly compliment them on. In relation to the point about what you can do, you could perhaps manage your mortgage with your unsecured debt. A PIP and a DSA, without knowing the full breadth of circumstances, seems like an issue that you should look at and should consider. And that's as succinct as I could make it.
Yeah, I mean, if you have only one secured debt, I think a proposal for a debt settlement arrangement can be made if your lender is prepared to play ball for the time that it takes to get unsecured creditors dealt with over the 5-year period of the debt settlement arrangement. But I presume you're still in the CCMA MARC process, which Bank of Scotland aren't, even though they've left the country and their debts are now been dealt with by Certis and Bluestone and other companies. They're still obliged to comply with the Code of Conduct on mortgage arrears. You have rights of appeal. You've correctly identified, though, that the FSO won't take an appeal on substantive matters as far as we're aware. And we'll wait and see what the revision comes up with. But it looks like you'll be driven into the Personal Insolvency Act and either a DSA or PIA proposal. But, the machinery is certainly far from perfect. It's full of flaws, full of holes. And unfortunately, I don't see that been remedied very quickly. Something has, but not enough.
Something has, but not enough. I think that's exactly right. Chris, are you happy that we leave it at that?
Absolutely.
Okay, I'm going to close the seminar at this stage. I want to thank you all very much for staying with the programme, right, to this particular point, and for being so attentive the whole way through. I think we have learned an awful lot, got an awful lot of information from all of the speakers, and in particular I just want to again just note the level of the materials that we received from both the Insolvency Service and from Chris Lahan, which are entirely new materials, which are really useful. I think we've seen maybe something about the various infrastructures that are there, that are not enough. which do require creditors and lenders to behave like ladies and gentlemen. And we have not seen enough of that in the past, I think, to make us trust that. But we I suppose, we will see what happens. We've also seen again how difficult all this is going to be without a proper infrastructure for advice and assessment for everybody who is over indebted at the moment. And I think we have seen, particularly in the later questions, the real puzzle for poorer debtors who can't afford a personal insolvency arrangement or a debt settlement arrangement is going to be very problematic for some people. So thank you all the speakers very much. So Lorcan O'Connor and indeed his team at the Insolvency Service as well. Chris Lahan, the official assignee in bankruptcy. Colette Bennett of MABS NDL and project manager for the approved intermediaries. Tom Murray from Friel Stafford, and our own Paul Joyce. Thank you all very much for your talks. I think we'll give all of them a round of applause. We hope that this has given something extra for FLAC volunteers as well, and we remain profoundly grateful for the partnership that exists between our volunteer and our paid staff in FLAC. And we are absolutely satisfied it could not be done without you. We're also extremely grateful for all the interns who work with Jacqueline Heffernan on the information line, who again take an awful lot of the stress and strain of people and hopefully help to alleviate it as well on our telephone line. So hopefully then we'll be able to spread this work out into our clinics. There is an evaluation form. Somebody leaving at the interval said, this was a very dynamic session. I said, would you mind pulling out your evaluation form and writing that down? That's the kind of thing we want to hear. If you could take a moment to fill it in, that would be absolutely marvellous. I want to thank also the people who put this event together at quite short notice. We were busy watching the Insolvency Service to see when their information would issue and then to try and pick something up. But I want to thank our team in FLAC, a real good team if ever you're looking for people to put together an event like this. Emma Cassidy, Paul Joyce, very involved with it as well, Rachel Ferguson, Yvonne Woods and Emer Butler, who was the central hub of the whole thing. You did a great job, guys. Thanks also to all the interns who've been here registering and miking and all the rest of it as well, and all the staff who've been here for the day. Thanks very much for that. Now, I have a final thing I want to say. We are an NGO and we are always looking for money, and we didn't decide to ransom Chris Lahan's notes in the end. But there is a little box out there if anybody. We thank people who did make donations indeed, and we have received donations towards this event. We're seeking to cover the cost of the hall, as they say. So we are very grateful for those. If you want to put something in the box. But the other thing is, a lot of FLAC volunteers are doing, the women volunteers are doing the mini marathon and the first weekend in June. And some of us have forgotten about the fundraising aspect of this until very recently. So if anyone wanted to sponsor any of us for the mini marathon, we have the FLAC Women card here, where you can sponsor all of us to do it together if you want for an amount. You don't have to do any of the above though, and in particular this is a small bit of a gift, I suppose, back to our volunteers in particular. It'll assist in the work of FLAC, but maybe it'll also be of assistance to yourselves. So thanks very much one and all, and safe home, and that's it, we're finished.